That's what the left is planning. They're planning for Congress to overrule the vote of the people. We had a major Supreme Court ruling this week, 9-0 against the left and Democratic parties' really dishonest attempt to remove President Trump from the ballot, citing Section 3 of the 14th Amendment, which in theory would allow certain officers of the United States to be ruled ineligible to be in office or maybe removed from office if they engaged in some type of insurrection. Of course, that section of the 14th Amendment was passed after the Civil War. And the way the amendment reads, it doesn't apply to Trump. Frankly, it just doesn't apply to Trump. And it certainly doesn't authorize state judges or election bureaucrats or politicians to remove a president from the ballot based on their personal opinion after show trials and fake investigations that he engaged in insurrection. And the goal to remove Trump from the ballot, as I've said before, is an effort to really turn America. It's part of an effort to turn America into a one-party state. What better way to turn our country into a one-party state than to eliminate from the ballot the number one candidate for the presidency? Now, that's what happens in third world countries. Certainly, as I've discussed before, Putin and the dictator in China, in Cuba and elsewhere, they would recognize what that's all about. And thankfully, the Supreme Court, at least for now, resisted the left's efforts in a unified way to require the president or require the removal of Trump from the ballot in various states. Now, Judicial Watch, along with our friends at the Allied Educational Foundation, we had filed an amicus brief highlighting the chaos that would result in the various states engaging in determinations as to whether or not a candidate was eligible for the presidency under this clause. And as I've highlighted, and I think we highlighted in this case, that if they want to play the insurrection game, there's a lot that can be said about removing Biden from the ballot, certain members of Congress from the ballot for engaging in insurrection, because insurrection, it depends on who's defining it, right? And they've defined it to mean anyone who disputed the 2020 election and tried to pursue that dispute through law, under our Constitution, under federal law, and in Congress. Now, others might define insurrection as those blowing up our immigration law and allowing an invasion of the United States. It's in the eye of the beholder, right? And the Supreme Court saw through that and said, no, 9-0. That means every justice, including the extremists who are on the left on the court there, Justice Jackson, Sotomayor, and to a certain extent, Elena Kagan. She's probably not as far to the left as the others, but they're a reliable bloc. They all agreed that this was inappropriate. So I encourage you to read the decision in its entirety. It's accessible. We'll put a link to it below. But I'm going to read to you a key section of the decision, one which I think that even the liberals didn't disagree with. This is kind of the core holding. Conflicting state outcomes concerning the same candidate could result not just from differing views of the merits, as I highlighted, but from variations in state law governing the proceedings that are necessary to make Section 3 disqualification determinations. Some states might allow a Section 3 challenge to succeed based on a preponderance of the evidence, while others might require a heightened showing. Certain evidence, like the congressional report on which the lower courts relied on here, might be admissible in some states, but inadmissible hearsay in others. Disqualification might be possible only through criminal prosecution, as opposed to expedited civil proceedings in particular states. Indeed, in some states, unlike Colorado or Maine, where the Secretary of State recently issued an order excluding former President Trump from the primary ballot, procedures for excluding an ineligible candidate from the ballot may not exist at all. The result could well be that a single candidate would be declared ineligible in some states, but not others, based on the same conduct and perhaps even the same factual record. The patchwork would likely result from state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole. And they were quoting a prior Supreme Court decision with that language. But in a presidential election, the impact of the votes cast in each state is affected by the votes cast, or in this case, the votes not allowed to be cast for the various candidates in other states. An evolving electoral map could dramatically change the behavior of voters, parties, and states across the country in different ways and at different times. The disruption would all be the more acute and could nullify the votes of millions and change the election result if Section 3 enforcement were attempted after the nation has voted. Nothing in the Constitution requires we endure such chaos, arriving at any time at different times up to and perhaps beyond the inauguration. So, really, no, that was what the Supreme Court said. And this was my initial reaction to it as it came down. Hey everyone, Judicial Watch President Tom Fitton here is some great news. The Supreme Court ruled 9-0 in favor of President Trump. He will be on the ballot, and the left's efforts to rig the election by removing him from the ballot, frankly, an effort to turn America into a one-party state, has been thwarted by both Republicans and Democrats on the United States Supreme Court. It's a big victory for the Constitution, our constitutional republic, and the rule of law. Now, the left isn't going to stop. They're still trying to jail Trump. But in the meantime, Judicial Watch was proud to participate in this case, and the Supreme Court has more work to do to stop the left's efforts to rig the election. So, of course, the left can't help but try to preserve its ability to disrupt and destroy the republic. And accordingly, the three justices on the Supreme Court on the left were upset with what turned out to be a majority, it looks like, because Amy Coney Barrett didn't want to go there too, but for different reasons, and didn't want to support the left's crazed attack on the court decision. So the three leftists agreed with the court holding that states don't have any power to do what they propose to do here, which is to essentially upend our federal presidential election by engaging in a piecemeal analysis of whether the president is eligible or a candidate is eligible under this clause of the 14th Amendment. And the Supreme Court noted that only Congress can enforce it through appropriate legislation. Now, the court, the three justices, they got nervous about that, right? Because they saw through that 5-4 holding, essentially, which is broader than and more specific than the underlying issue that the states can't mess around here, because they want the option, it's clear, for federal judges to come in and throw Trump off. And they're also planning, and this is something that we need more discussion about, because they were also similarly planning in 2020, the left is thinking of ways to upend the election if Trump wins, not because they dispute the outcome of the election in terms of votes cast and the appropriate nature of the election process in terms of, fraud and things like that. They just think that if Trump wins, he should be thrown out and be ruled ineligible from office using this and other reasons, like the 14th Amendment. He was an insurrectionist, so he can't be president even if Americans select him as president and elect him as president. And it seems to me there are three justices on the Supreme Court who are trying to preserve the ability of the left to upend our republic that way. So in many ways, this case is very satisfactory in the end, because it walled off, for practical purposes, the effort to remove Trump from the ballot. But the reaction to it, and even the three judges on the court, the three justices on the court, their reaction to it suggests the game is not over. They're thinking of other ways to try to remove Trump from office. Some might call that an insurrection, right? Some might call that a coup. Those are the new rules, and that's what the left is planning. They're planning for Congress to overrule the vote of the people. Now, this current Justice Department is prosecuting people who did that, who wanted to challenge the election and use the Electoral College process to challenge the outcome of the election and from Trump's point of view, vindicate the lawful outcome. Here, they're not even questioning whether the outcome's lawful or not. They just don't think Trump should be president. Now, under the Justice Department's new rules, they should be subject to investigation for conspiracy, right? You don't have to commit the crime. You can conspire to commit the crime of insurrection and to obstruct an election. But of course, you know the Justice Department isn't going to do that. But just shows you how the Justice Department has been hijacked by the left to promote basically the destruction of the candidate that is most likely to beat Biden. Well, frankly, right now, Trump is going to be the nominee, absent an act of God. He won Super Tuesday. Haley Barbour, excuse me, I keep on saying Haley Barbour. I date myself. Nikki Haley has removed herself from the race, so he's going to be the nominee. And now the target is they're going to accelerate, in my view, their operations against Trump, their illicit operations against Trump to try to rig the election. So, you know, as I say here, it was essentially, and I'm giving you all the kind of the warnings about the challenges to Trump, and our whole system, our constitutional republic won't stop with this ruling because the court has more to do. But it was a good day. Yes, it was a good day for the rule of law with that Supreme Court decision. The Supreme Court made a powerful and unified statement against the brazen, unconstitutional coup by leftists against the constitutional rights of tens of millions of Americans. And thankfully, a Supreme Court majority seems prepared to stop any shady Biden administration and leftist congressional efforts, and I would add judicial efforts, to overturn any Trump victory, again, as I said, based on false allegations of insurrection. So a big victory for the rule of for the rule of law, but now Trump faces other challenges. They're still pursuing him in federal court with these fake charges related to documents and challenging the election outright. And then, of course, you have the Soros prosecutor up in New York, Alvin Bragg, who is pursuing a prosecution based on a confidentiality agreement and suggesting that somehow that confidentiality agreement violated federal law. So how you tie federal law to a state prosecution, well, that's an interesting mess he's trying to make up there. But of course, you know, an unprecedented novel application of the law is a key test, in my view, to figure out and to help you figure out whether a prosecution like this is justified. And it's obviously a Democratic Party, because Alvin Bragg is an elected Democrat. He's not an appointed prosecutor. He's an elected prosecutor. It's a conspiracy. Now, you can argue whether it's unlawful or not, but it's a conspiracy to target Trump with this prosecution up in New York. So that's the next case he's facing. And you can bet the left will use that outcome, which before a New York jury is almost preordained, right? New York City jury, given the partisan makeup up there. So we're still in banana republic territory, folks. But Judicial Watch won't back down. We've got our litigation to uncover what the DOJ has been up to uncover what Fani Willis has been up to. We're monitoring quite closely, and we've litigated over what Alvin Bragg has been up to. You know, we're just not going to stand by and watch the destruction of our republic. We're going to go into court and expose what's going on so you have full access to what your government's up to and the corruption involved in a way, and the corruption that is so destructive to the American way. So with your continued support, you can be sure that we will continue to litigate, investigate, and educate about this dire threat to our Republican form of government through the illicit and illegal targeting of President Trump. And by the way, I want to add something about Trump winning on the election. And don't take this as an endorsement of any candidate, because I'm not allowed to do that, at least through Judicial Watch. I can do it personally. But as president of Judicial Watch, I'm not endorsing or opposing any candidate. But certainly from kind of an objective political analysis view, my view about the president, his remarkable comeback, by any standards, a remarkable comeback of his gaining the nomination again, he's about to gain it officially soon, is really a dramatic and historic repudiation of voters of the left's attempts to rig the election, to abuse the rule of law, abuse Trump and other innocents. They're not buying it. And the left has put this narrative out there about January 6th, about the 2020 election, all designed to make it impossible for Trump to come back. And the voters said, no, we're not buying any of it. They rejected their corrupt narratives, their dishonest narratives, narratives designed to destroy your First Amendment rights, help them rig the next election. And voters weren't buying it. And it wasn't just Democrats. You had some Republicans doing this as well, because they just don't like the conservative brand that Trump was selling. So they were willing to let this abuse happen and endorse it. But it didn't work out. And it doesn't mean the threats aren't over from those abuses. But the voters, certainly on the Republican side of the sphere, are saying, we don't buy any of this.
Thanks for watching. Don't forget to hit that subscribe button and like our video down below.